Well, there we go. All right. Okay, welcome everybody to the third webinar of the Justice System and Psychiatry Grand Round series. This is a collaborative educational series between the psychiatry departments at the University of Toledo, the Ohio State University, and the Attorney General's Task Force on Mental Illness and Jails. So you've heard from us so far about the intersection with the mental health courts. And then our second talk was about crisis intervention team, CIT training. So today we bring you another variation of that intersection. And so we will be talking about civil issues, criminal issues, and that intersection. So at this point, I'm going to turn it over to Dr. Tilley, who is going to be a presenter and a moderator for the rest of the program.
Thank you, Dr. Kelly. Good afternoon, everyone. So to kick us off, I'm going to turn things over to Justice Stratton in just a second. We'll briefly review the objectives that we have for today. We think this is a relatively modest agenda. We want to be able to help you raise awareness of the intersection between these two concepts, describe the role of the judicial system in that intersection, and understand the importance of competency restoration process, as well as the insanity plea. Now, there's a chat feature, so we'll look to you to have you put your questions in the chat box. And at the end of today's presentation, we will endeavor to leave a portion of time for Q&A, and we'll address your questions there. So keep those questions coming. Often, I think that's probably where the best material comes from, maybe not so much from what you are able to glean from a particular slide, but you've got a fairly nuanced question that we'll be able to provide some insight to, and you can take with you. So with the objectives covered, let me turn it over to Justice Stratton for some introductory remarks. Justice Stratton.
Thank you so much. And it's a great honor to be with this panel, who I respect and have worked with on many levels, and also to be involved in the third Grand Rounds. The Grand Rounds were started when I was a justice on the Supreme Court, and we started doing this to try to educate the students and other training facilities on the intersection of mental health and criminal justice. And that program was discontinued for a while, and we've decided to pick it up again through the Attorney General Task Force that I co-chair with Attorney General Yost. And we are now in our third series. We focused on the criminal system for the first two, mental health courts, and we focused on crisis intervention teams, which are officers trained to respond to those calls. But there's a whole civil side involved in the justice system that is an intersecting with the criminal justice system. They go back and forth between, and we hope you'll understand that a little bit better when we get through this system. So if I can go to the next slide. So basically in the 1950s, the hospitals were not very good facilities. Some of them were pretty bad. Some of them were decent, but there was a big movement to move people to the least restrictive environment. So they closed the majority of the state hospitals and moved them out into the community, but they never created the system to take care of people in the community, which was a huge issue. And the second issue is that people who had mental illness did not believe they had mental illness. So even if they were had a mental illness, they would not seek treatment. Those factors combined with the lack of resources, lack of treatment, basically they ended up homeless on the streets, often in jail or prison, and the jails and prisons became the largest psychiatric hospital in the country, in almost every state. It's that way in Ohio. So we have been working to try to reduce that cycle of going in and out of the criminal justice system and the civil commitment system, and get them back into the community and back into treatment. And that's the whole movement. So the numbers that you see here on this slide and the next slide, I won't read them because you will have those available, but it just shows the huge number of people in the community with mental health issues, many of them untreated, and how the state psychiatric beds are all taken up with criminal justice involved parties. And so we're trying to break this cycle. And this just shows you the civil side that is going to be the focus of this presentation. And so we hope that by looking at these slides, listening to the presenters, you will get involved right away, early on, in becoming part of the solution, whether you get involved in the civil justice system, the criminal justice system, in the treatment system, to help us kind of reverse the cycle of jails and prisons being the de facto mental health hospital. That's our goal. And we hope by reaching you early and young that you will become passionate and advocates about this and try to do your own part to make a difference. And so that's just a quick background of what we're trying to work on. This is like the third in our series, focusing more on the civil commitment process, which intersects with the criminal justice side. And we now have 3 very excellent speakers who bring a very diverse background to helping you understand this issue and what you can do to make a difference. So thank you for allowing me to be part of this process. And I'm very honored that I have such good partners in the presentations. And I thank Dr. Kelly and Dr. Niedermeyer for all their work in doing and helping us. And now I'll turn it over to Dr. Tilley again.
Thank you, Justice Stratton. If many of you probably know who Justice Stratton is, if you don't, you do now. And if you operate in this space, anything involving criminal justice and mental illness for any length of time, you will soon know her very well. She is a champion for many fantastic causes. And she is really the motivating force and the driver behind a lot of these projects and fantastic endeavors that are done in this state and across the nation. So we owe her a great deal of gratitude. And we're very happy to be working with her on these and other projects. So I wanted to take some time before we got into the content for today's presentation to at least do a brief introduction. So let me turn it over to Magistrate Morris to say a couple of words.
Good afternoon, or I guess it's afternoon. I'm pleased to be here. I'm here mainly because I've been dealing in this mental health area since 1976 when I was a law student at the Franklin County Probate Court and was the clerk in charge of the mental commitment process. And I like to say I've done everything in this area except be a patient or a doctor. I've been a bailiff, I've been a lawyer, I've been a magistrate. And some people think I probably would have done me some good to be a patient at points in my life. But I've got a lot of experience in this area, and I'm looking forward to any questions you might have as well once we're done to try to clarify things for you.
Thank you, Magistrate Morris. And next, let me turn it over to Christina.
Good afternoon, everyone. My name is Christina Shane-Baez. I'm an attorney with a master's in social work. So I started early with the intersection of criminal justice and mental illness. I am currently the Associate CEO for the Ohio Association of County Behavioral Health Authorities, for the statewide organization that represent the ADAM boards around the state, the alcohol, drug addiction, and mental health boards. Prior to that position, I spent 13 years in private practice, with my niche being in behavioral health law, confidentiality laws, public agency compliance issues. And I am currently Dr. Tilley's co-chair on the Competency, Restoration, and Probate Court Committee of Justice Stratton's task force. Dr. Tilley?
Thank you. Though Christina's wrong. She's not my co-chair. I'm her co-chair. So, good afternoon, everyone. Again, I'm John Tilley. It's a pleasure to be here. I am a clinical and forensic psychologist. I've been in private practice for about 20 years. And through my private practice, I've had the opportunity to conduct a fair number of evaluations for competence to stand trial, sanity, and civil commitment. So what I'm able to offer today will be gleaned in part through my experiences in conducting those evaluations through my practice as a forensic psychologist. So For an overview of the content that we have planned to present for you today, I will go over some definitions and some foundational issues, including nuts and bolts related to competency and sanity. Then Christina will go over the competency restoration process and talk more about avenues for restoring competency. And then we'll finish up the content with Magistrate Morris, who will cover probate court commitment. And then again, we're going to endeavor to leave some time at the end for question and answers. So please put those questions or topics for discussion in the chat box, and we'll get to those a bit later. So as a logical starting point, we want to differentiate criminal courts from civil courts and operationalize what courts we are talking about today. And in Ohio, for adults, the criminal courts are composed of common pleas courts, which handle felony offenses, and municipal courts, which handle lower level offenses, being misdemeanor offenses. And criminal courts conduct hearings to determine at times criminal culpability, or in other words, guilt. The issues of competence to stand trial and sanity are addressed by the criminal courts. Now, sanity is a term that has a number of synonymous terms, including not guilty by reason of insanity, which is the plea as well as the finding, and that's referred to as NGRI for short. Others sometimes refer to it as criminal responsibility. Again, these terms are all relatively interchangeable, and they should be considered synonymous for present purposes. There are a number of different civil courts. The civil court that we are going to be concerning ourselves with today is a probate court. It oversees the involuntary commitment process of individuals who are alleged to be mentally ill or intellectually disabled, or both. And the probate court conducts a variety of hearings, some of which are to determine whether an individual is subject to court-ordered treatment. And so as an overall or overarching theme for today, we're going to be emphasizing the process by which an individual, and specifically a defendant, transitions from the criminal court to the probate court. There are processes in place, and there's been recent legislatures that's been passed that's helped to streamline that process, with the idea, kind of going back to what Justice Stratton laid as the foundation, is that there are a lot of seriously mentally ill individuals that are involved in various systems, including the criminal justice system. And that creates burdens, not only for those individuals with serious mental illness, but for the systems that are entrusted with providing them some type of service. And so the overall idea has been for these various systems to work together to move individuals who don't really belong in a criminal justice system or in a criminal court, move them to a civil court or to a probate court, because that's going to be what meets their needs, and that's what's going to streamline the process of linking those individuals with the necessary care that they provide, while still preserving the safety of the community and the integrity of the justice process. So mental illness was a term that was introduced on the previous slide, and there is an operational definition for what constitutes mental illness. So mental illness is statutorily defined, and the definition is provided here. You can easily find that in the Ohio Revised Code. So when we are concerning ourselves with a defendant being mentally ill or intellectually disabled, and we're going to talk more about that in just a bit, there's a specific definition that we use to help conceptualize what constitutes mental illness. And similarly, intellectual disability is statutorily defined. It too is located in the Ohio Revised Code. And it is, as what you might imagine, it's a disability that's characterized by very low intellectual functioning, as well as concurrent deficiencies in adaptive functioning. And so both the criminal courts and the probate courts very much concern themselves with issues of mental illness and intellectual disability. The determining if a defendant or an individual is mentally ill or intellectually disabled or both it happens both at the criminal court level as well as the probate court level. And in fact, whether or not they have an mental illness or an intellectual disability helps to facilitate their transition from the criminal court to the probate court. Now, defendants are presumed to be competent to stand trial, and thus it's incompetence that has to be proved and or established, and that is determined by a court after a hearing. And the key components for incompetence is the defendant's present mental condition being impaired to the extent that the defendant is incapable of either understanding the nature and objective of the proceedings or assisting in his or her defense. Now, note it's an or there and not an and, meaning that there are two prongs for competency: the capacity to understand the nature and objective of the proceedings, and the other prong is the capacity to assist in one's defense. Only one of those prongs needs to be impaired in order for the threshold for incompetency to be reached, meaning that they don't both have to be impaired. Either of them by themselves is sufficient to rise to the level of incompetence. Now, sanity is a separate issue, and many laypersons don't appreciate that. In fact, a lot of times competency and sanity are viewed as interchangeable when they are not. In fact, I've lost count of the amount of times that I've conducted a competency to stand trial evaluation, and when I get to the part of asking the defendant to tell me what a plea of not guilty by reason of insanity means, they reply with something like, "It means you're not competent to stand trial." And then that's not the case. Those are two very different psycholegal concepts, and we're going to compare and contrast those more in just a bit. But first, insanity or a finding of not guilty by reason of insanity is established if at the time of the commission of the offense, the person did not know, as a result of a severe mental disease or defect, the wrongfulness of the acts charged. So these two concepts are fundamentally different in a number of ways. Even though they often go hand in hand, they are much different concepts. Competence to stand trial and evaluations of those really concern themselves, for the most part, with current functioning, meaning what is the defendant's present mental condition. And the purposes of doing that examination is to offer some opinion as to whether or not their mental condition is presently impaired to the extent that they are incapable of understanding and or assisting. In contrast, sanity or criminal responsibility evaluation concerns itself with the defendant's functioning at a previous time. Sanity evaluations always involve a retrospective analysis, meaning we're going to look back at a particular period of time. It could be a month prior, it could be a year prior, it could be 15 years prior, depending on the type of evaluation that's involved, but it's always going to be retrospectively analyzed. Whereas again, competency pertains to current functioning. And sanity, the idea is to arrive at some opinion as to whether or not the defendant had a severe mental disease or defect that impacted their knowledge of the wrongfulness of the acts charged. And really, the defendant's functioning at that previous time, their mental state at that previous time is fixed, meaning it was what it was and it will always be that. We can't go back in time to change that. So sanity evaluations are concerning themselves with a very fixed thing. On the other hand, competency to stand trial evaluations are pertaining to a very dynamic construct, meaning a defendant's mental condition presently can change. So competence to stand trial is dynamic. It can fluctuate. It is fluid. A defendant can go from being incompetent to competent. In fact, that's what competency restoration is all about. It's about moving a defendant who is presently incompetent to, in the future, being competent. And Christina is going to talk about the competency restoration process in just a bit. But it can also flow the other way, meaning that a defendant can at one point be competent, and then moving forward, something can happen with their mental condition, causing them to deteriorate to the point of they become incompetent. I've been involved in a few cases in which a defendant started a trial on day one being competent, and by day 2 or day 3 of that trial, their mental status deteriorated to the point where they fell below the threshold of competency, in fact, were incompetent. So if an examiner conducts an evaluation for competency and offers the opinion that aligns with the defendant being incompetent, meaning they've offered some opinion about them being incapable of understanding or assisting, then examiners are also obligated to offer an opinion as to whether or not the defendant is mentally ill or intellectually disabled. So here we see that the criminal court's giving specific consideration to issues of mental illness and or intellectual disability. And in fact, if the opinion is that the defendant is intellectually disabled, the examiner is also obligated to offer additional opinion as to whether or not the individual appears to be an intellectually disabled person subject to institutionalization. And that too is statutorily defined. Essentially, it's when the defendant has a moderate level of intellectual disability, meaning an IQ of 55 or lower, as well as some other risk factors that essentially make it unsafe for them to be in the community or in their present situation and require some type of intervention. If the examiner offers an opinion about incompetency, they are also obligated to offer an opinion about restorability, meaning whether or not the defendant is restorable to competency in the time allotted by law. And the amount of time that's allotted for restoration is determined by the severity of the defendant's offense. And offenses, special felonies like aggravated and murder are allotted 1 year for competency restoration, meaning that in those cases, the defendant could be subject to treatment for restoration purposes for up to a year. Also, felonies of the first and second degree that are offenses of violence are also allotted a year for restoration. Other felonies are allotted 6 months. Misdemeanor offenses, on the other hand, are allotted far less time. Misdemeanors of the first and second degree are only allotted 60 days, and all other misdemeanors are only allotted 30 days. So relatively little time offered for restoration in misdemeanor cases. If the examiner offers an opinion that the defendant is incompetent and restorable, then the examiner is also to offer an opinion on what constitutes the least restrictive setting necessary to restore the defendant to competency. And those are really just one of two options, either inpatient restoration or outpatient restoration. Now, sometimes there's not really a decision to be made because the statute determines what level of offense is required or eligible to receive restoration in certain types of environments. And Christina is going to get into that a bit more in just a bit. But as an examiner, in offering those opinions as to whether or not an inpatient or outpatient setting is required, also need to consider other factors like what is the defendant's housing situation and housing needs, what are their treatment needs, and is the treatment that they require available to the defendant in the community, and also consideration has to be given to the safety of the community. Now, to provide a segue and to set the stage for Christina, in August of 2021, Senate Bill 2 was passed. And that was legislation that had these kind of concepts in mind, this idea of the seriously mentally ill, requiring diversion out of the criminal courts and to the probate court. And so with that legislation came important changes to the statute that affected the competency restoration process. And so with that said, I'll turn it over to Christina.
Thank you, Dr. Tilley, and thank you for explaining the framework within which the competency restoration process occurs. As Dr. Tilley mentioned, that's what we are going to move into at this point. Dr. Tilley, can you advance the slide, I do believe? Oh, wait, I'm sorry. Nope, you're good.
Okay.
I had a different slide prior to that one. So as Dr. Tilley just noted, Senate Bill 2 went into effect in August of 2021, and it made some major changes to Ohio's competency restoration process. And the impetus for Senate Bill 2 was driven in part by a few different issues. One being that in Ohio and across the nation, there's been a sharp increase in the number of persons being referred for competency restoration, and in particular for those that have been charged with misdemeanor offenses. In some states, the increase led to exceptionally long wait times for hospital beds to receive competency restoration treatment, and that resulted in lawsuits in a few different states, actually. Ohio hasn't experienced those crisis levels or the lawsuits, but we have definitely seen the increased time for forensic beds lead to access issues in Ohio's regional state psychiatric hospitals, with forensic referrals crowding out access for civil patients. So, and there was also an ongoing concern about lower level offenders being sent to state hospitals for inpatient restoration, and whether that was the most appropriate path for those offenders instead of keeping them in the community or routing them to mental health treatment. So prior to Senate Bill 2, the competency restoration statute, for the most part, required competency restoration treatment to be ordered when a person was found incompetent but potentially restorable, regardless of the charge against them. Alternatives for lower level offenses weren't addressed. And although outpatient competency restoration wasn't prohibited by the statute, it also wasn't contemplated. So it wasn't often used. So that process was just exacerbating the access issues and the concerns about low-level offenders being sent to state hospitals for restoration. So with Senate Bill 2, under our newly revised statute, the process now prescribes what must be ordered based on the charge against the defendant, felony, violent misdemeanor, or non-violent misdemeanor, and whether it's likely they'll be restored to competency within those maximum timeframes that Dr. Tilley described, or whether restorability can't be determined at the current time. It requires alternatives to inpatient competency restoration to be ordered for lower level offenders. And it also provides for a prosecutor to make a recommendation to the trial court that alternatives to inpatient competency restoration be used specifically for persons charged with violent misdemeanors. And the next few slides go into each of those changes in a little bit more detail. So with the next slide, you'll see that there are two new competency restoration paths or alternatives to inpatient competency restoration that trial courts are required to use for those lower level offenses. So under the first path, the court dismisses the charges against the defendant without prejudice. Without prejudice, meaning that the charges can be refiled for the same conduct at a later date if need be. After dismissal, the person must be discharged unless the trial court or the prosecutor files an affidavit of mental illness in probate court because they believe the person meets the criteria for mentally ill person subject to court order, which is a civil process. If an affidavit of mental illness is filed, the trial court's able under the new statute to detain the person for 10 days pending that hearing in probate court to determine whether they do indeed meet that criteria. That first path is required to be used by the trial court for non-violent misdemeanors when the court is unable to determine if the person can be restored to competency within the maximum timeframes if they're ordered to competency restoration treatment. It's also one of the options available to the court when the court determines the person's likely to be restored within the maximum timeframe and the charge is either a non-violent misdemeanor or a violent misdemeanor where the prosecutor has made that recommendation for an alternative to be used. The second option available to the court for those non-violent misdemeanors and violent misdemeanors with prosecutor recommendation is ordering the person to outpatient competency restoration. So specifically routing them still to competency restoration treatment, but on an outpatient, still in the community basis, and not that inpatient restoration that was traditionally used even for those lower level offenders. On the next slide, you'll see a flow chart that we drafted to assist in understanding what the court's required to order under the new competency restoration process. I won't go over this in a lot of detail, but I think it is helpful to get a sense of how the new process operates. You'll see up in the box in the left-hand corner, those two alternative paths I just described are listed. And then the flow of this chart is based on whether the court determines that the person is unrestorable, likely to be restored, or is unable to determine restorability at that time. And then it's further broken down by the level of the charge, violent misdemeanor, felony, nonviolent misdemeanor, and then further by whether the prosecutor has made a recommendation for those violent misdemeanors that are likely to be restored. So this hopefully is a helpful tool for you to help understand the flow of this new process. On the next slide, you'll see that Senate Bill 2 also provides procedures for the transfer to the civil side. So I talked about the affidavit of mental illness being filed by the trial court or prosecutor under the competency restoration statute. Because that affidavit of mental illness is being filed with the probate court, which is on the civil side, there are procedures for that transfer to the civil side. The trial court is required under the statute to send all records related to the person's competency determination to the probate court, so that the probate court has the relevant background information as a starting point in determining whether the person is indeed a mentally ill person subject to court order. And the next slide, please. The affidavit of mental illness form was also changed to make it clear when the affidavit is being filed by a trial court or a prosecutor under the competency restoration statute, and they have to include their name and address on the affidavit so that the probate court can reach back out to the criminal side if need be. Senate Bill 2 also amended the civil commitment statute. Dr. Tilley had read the definition of mental illness, the statutory definition, and that definition resides in Chapter 5122 of the Ohio Revised Code. That is the section that addresses civil commitment. And because we do have this transfer from the criminal to the civil side with this process, amendments were made specifically about persons that come over to the civil side from that process. It states that for persons that were transferred in the previous 12 months that are now on voluntary status under the civil commitment statute, they applied for and were given a voluntary status as opposed to the original involuntary status of commitment. The hospital is required to notify the trial court or prosecutor when a voluntary patient is either non-compliant with their treatment or has requested release and the hospital has decided not to initiate an involuntary process. After that notice is provided to the prosecutor or trial court, who's ever listed on that affidavit of mental illness, the hospital is required to hold the person for 3 days while the trial court or prosecutor determines whether they want to file the affidavit of mental illness. And if an affidavit's filed, the person's discharge from the hospital is postponed until the probate hearing and the records of the person's treatment are sent to the trial court. The next slide, please. The last change to the civil commitment statute under Senate Bill 2 is a change in process for the probate court. Senate Bill 2 didn't really affect the probate court's process much, except for this change, because once the affidavit of mental illness gets filed with the probate court, they follow that affidavit and the hearing process through as they would regardless of how the affidavit was initiated. But the one change that does affect the probate court process is just like I explained on the last slide. A hospital is required to notify the criminal side when there's a change to that person's status. A probate court must notify the prosecutor or trial court when it terminates jurisdiction over a person that had just come in under the competency restoration statute in the previous 12 months. So if the person is admitted as a voluntary patient, there's a finding that the person no longer meets the criteria, the hospital determines the person no longer meets the criteria, the probate court must let the trial court know that they are terminating jurisdiction and transfer all probate records to the trial court. I've hit a lot of the high notes for the new competency restoration process. So I think that is a good segue to turn it over to Magistrate Morris for a closer look at the probate court commitment process and how it's actually implemented. Magistrate.
Turn on my mic. Well, the first thing you'll notice with the probate process is it is a civil process, and it's mainly there for when the patient disagrees that they need treatment and somebody thinks they do. And large part of that is the right to the patient to sign a voluntary admission if they feel they need to be there. That automatically dismisses our case, period. And that's pretty strong in all of the commitment law here in 5122. I'm going to start, though, by making the statement I've made to a lot of lawyers in CLE cases, CLE presentations, and that is there are 88 counties in the state of Ohio, and there are 88 different ways of doing some of this stuff. So I'm going to try to give you a broad brush and some problems that everybody has, but basically every court does things a little bit differently. And I'll try to give you a couple examples of that as we go along. But the main thing you need to realize in relation to the Senate Bill 2 people is that just because you're not competent to stand trial doesn't mean you're a mentally ill person subject to court-ordered hospitalization. And that's why the slides that I've got here are mainly the definition of what is a person who meets that criteria. And there are basically 5 categories. And the first one represents a substantial risk of harm, of attempt to suicide or serious bodily harm. The second one is basically homicidal or other violent behavior. And then we can go on to the third one, which is a little broader, substantial and immediate risk of serious physical impairment. I'll let you read that at your own leisure. I don't want to read to you. And 4 is kind of a catch-all that they would benefit and that there's grave and imminent risk to their substantial rights. Now, all 4 of those, the probate court can enter an order ordering somebody to the hospital or retaining them in the hospital, send the sheriff out to pick them up, to get them to the hospital. But the 5th criteria is the outpatient treatment. And that's quite a bit different. And under no circumstances can we order the sheriff out in one of these that is just a number 5. In order to retain somebody against their will, you have to meet the first 4 criteria. The 5th one is more for when they're on their way out of the hospital to try to set up some kind of procedure to give them some follow-up in the community and a little bit of help staying on board so they don't end up back in the hospital. That being said, I think that's the extent of my slides because I really want to just give you a flavor for how the system works because there's not much time here. And let's talk about the developmentally disabled first, because you won't find a lot of them going through this Senate Bill 2 transfer to the probate court, because at least here in Franklin County, we've only had 1 civil commitment of a developmentally disabled person in the last year. And the reason for that is the guardianship procedures. Most of the people who have a developmental disability end up with a guardian if they need it. And the guardian can make all these medical decisions for the ward. And so we don't really have a lot of those, and I didn't want to spend a lot of time on it. But if you do get one in a criminal case and it is referred to the probate court, you absolutely have to have a letter from the local DD board saying that a civil commitment under 5123 is appropriate, because we cannot address your issue unless you have that letter. That's jurisdictional. And jurisdictional is important to courts because if you act outside your jurisdiction, then there's personal liability, and a nice thing called judicial immunity doesn't apply. So we tend to worry about those things. But going on to the mentally ill people, once an affidavit is filed in the probate court, that can happen a lot of different ways. I mean, a lot of times it starts with a 3-day hold in a hospital, and then or somebody goes as a voluntary, they went out, there's a 3-day hold put on. Within 3 days of their asking to be let out, you got to file an affidavit. That starts the whole thing. The affidavit needs to be backed up by facts. And that is one thing everybody across the state probably has an issue about. And as medical people, you need to remember that the person reading this affidavit is a lawyer. And a lot of medical jargon will mean nothing to them. I like to use the example, if you put down somebody has SI, well, I've been doing this a while, I know that means suicidal ideation in shortcut. But the better thing to say would be, this person is having thoughts of committing suicide or expressing delusions that somebody's telling them to commit suicide. You need to put it in concrete terms that have fact attached to it, as well as the medical diagnosis. Because otherwise the magistrate that looks at it to begin with might say, well, this isn't good enough. I remember having an argument with one of my fellow magistrates here. The doctor had put down that the patient was catatonic. And my colleague said, well, that's a medical term and that's just a diagnosis, that's not a fact. And we got in a rather heated argument because my position was catatonic describes a behavior. And if you're you're just not able to move because of your mental facilities, that definitely meets the criteria of 1, 2, 3, or 4. And but because it was a medical term and wasn't explained, if you just said this person's lying down and is totally non-responsive, we would have had that, no problem with that. So be careful when you use medical terminology, make sure it's reduced to a level where us lawyers can understand it. We have to have a hearing of some sort within 5 to 10 days of the filing of the affidavit. And that depends if somebody's in the community and we're picking them up. The 5 to 10 days runs from the day we issue the order to pick them up. So if the sheriff doesn't pick them up for 6 or 7 days, we're coming up short on the ability to have a hearing within 10 days. You can always dismiss that affidavit, refile another one that's timely, because timeliness is important in this area. But we always have, and this is one of the places where we might be slightly different than, say, Toledo or Cuyahoga County or Hamilton County. We always have a hearing of some sort within 10 days. And it's the only hearing we will have. Some people could have a probable cause hearing where the standard of proof is probable cause. We do a full hearing from the beginning, but we allow a patient who wants to sign a voluntary to sign a voluntary as long as it's before the hearing, so that they can take advantage of the dismissal and expungement that's available to them if they sign a voluntary. But we do a full hearing and we appoint a court doctor in every case. And I don't believe that most courts across the state do that either. They may appoint a court doctor as an independent expert to be the patient's doctor, but in a lot of cases across the state, I'm pretty sure the hospital doctor has to testify in all of these cases. In Franklin County, the court doctor kind of takes the place of the treating physician, because a long time ago, Judge Metcalf, who really originated a lot of our procedures here, felt that it was harmful to the therapeutic relationship of the psychiatrist to the patient to have to testify against him in court to keep him there. So we've always had a court doctor to take that role. and hopefully avoid the psychiatrist having to come in and basically be contrary to his patient. I imagine that helps the docs in Franklin County quite a bit, because you can say, well, if you don't want to be here, we're going to have to file and let the court decide. And then when they come back and the court said you got to stay, you're helpful in getting them out. But that hearing has to happen within 5 to 10 days. If you have a probable cause hearing and don't have a full hearing, you can have the full hearing in another 30 days. But we do that in Franklin County, we do it right away. The result of the hearing can be a 90-day order, an order not to exceed 90 days, I should say, which basically says this person is staying in the hospital and going to be treated as long as the hospital feels they need to be there. Now, most people recognize, and our lawyers tell them, that you're better off being a voluntary patient than you are being a court-committed patient. And I think you all would agree that it goes to insight and understanding of their illness. If they aren't willing to accept voluntarily the treatment, it's hard to believe that they know that they really have an illness, and it's tough to reach the point where you can let them go. But if they decide to sign a voluntary, they have the absolute right to, and it automatically dismisses our court case. We have what we call the one bite of the apple rule in Franklin County, because I think you can see that's open to some abuse by the patient, where they sign a voluntary, they get in, they don't get out in 2 days, and they feel like they went out again, so they sign another 3-day letter, and they're back in court again. But we will not let that patient sign another voluntary, because they already had that opportunity, and we will go ahead and have a court hearing. And nobody's ever contested that with us, but that is the procedure here in Franklin County. Want to leave some time for questions, but I do need to talk about outpatient. Outpatient is a very important process that's just really coming into its own here in the last few years, but that's one place where all the counties are different. I mean, our Summit County's outpatient program is quite a bit different than ours. But here, when you have an outpatient treatment going on, you have an ACT team that keeps track of the person and makes sure that they're taking their medication. And we have conferences with the patient along the way to get them before the magistrate and have what's known as the black robe effect. Hopefully try to keep them out of the hospital. In terms of Senate Bill 2 cases, we've had 46 of them as of last week. And of those 46, 26 of them signed voluntaries, which means that we notified the criminal court that we terminated jurisdiction, and now it's up to the hospital to let them know if they're getting out. We've had 13 go 90 days, and of those, 4 of them were signed in by a guardian, which could sign a voluntary admission on behalf of their ward if they want to. The only real hitch we've had with the Senate bill cases that I think you probably need to be aware of, and I'm going to throw Chris Boyd's name out there, who's the gentleman at the municipal court here in Franklin County that files these affidavits for us, because he's got a great handle on number one, making sure when the judge orders the referral to us that it is an appropriate referral and has the criteria for the mental commitment, meets the criteria for a mental commitment. The first case we ever had was dismissed right away because it didn't. But after that, we've not had one go that direction. And that's directly, I think, involved with Chris's involvement with the whole process. You also have to be careful when you get that 10-day order that the criminal case is dismissed and you have 10 days to file probate. Well, you need to start on day one, making sure you can find a bed somewhere for whoever this person is. Because if there's no bed, there's no place for us to put them. And the probate court cannot allow somebody to stay in jail under one of our affidavits for more than 24 hours. We have to let them go. So the timing of the filing of the criminal order and finding a bed is very crucial to getting this done properly. I think that's pretty much what I have for now. If we want to open up to questions.
Yeah, thank you, Magistrate. And thank you, Christina, for a lot of really fantastic content. And so we can, with our remaining time of about 10 minutes or so, we'll open it up for questions. I know that a question has come through the chat for you, Magistrate Morris. And the question is, why do so many treating psychiatrists in Franklin County still testify at the commitment hearings if there is a procedure in place for another doc to do that, and so therefore preserving the therapeutic alliance? Do you have any insight?
If I could have planted that question in the audience, I would have done that. The reason is we've only got 2 doctors that do those for us.
Yeah.
And when somebody asks for an independent expert, one of them has to be the independent expert. And a lot of the people that go through the system are what, for lack of a better term, I call frequent flyers. And if they were an expert evaluation for, or an independent expert for the person last week, they can't be the court doctor the next. We are in desperate need of doctors to perform those evaluations. But if either of the 2 doctors we have that do them cannot do it for some reason or is on vacation, then somebody has to present the case as to why the person needs to be in the hospital. And that can only be the treating physician or somebody from the hospital.
That seemed to be pretty clear to me. Glad that your accomplice was able to plant that question in the chat box for you, Your Honor, to tee that up for you.
Yeah, in case you didn't notice, that's a plea for anybody out there who wants to do this. We'll be glad to talk with you.
Yeah. So other questions, if they're not.
I'm sorry.
Okay. Yeah,
I received a question that came directly to me that I think would be for Magistrate Morris to weigh in on. I think that would be valuable. And the question is, if someone has a DD diagnosis, is it accurate that probate court must receive a letter from the DD board in order to place the client on outpatient commitment?
Yes, that's absolutely correct. You also have to, and you have to have that prior to filing the affidavit. The affidavit really can't be filed without that under the statute. You also need a comprehensive evaluation, but there's provision for them to take 30 days to get that done. But that's jurisdictional to the affidavit, and we would refuse it if it didn't have that. Which I'm sure that's why we don't get those, because the DD board would rather have a guardian in place to provide the ongoing care that the person needs.
Well, I think we've stunned everyone into silence. We bludgeoned them with the content. They have been rendered speechless. Certainly, it's been our pleasure to present to you today. A big thanks to Dr. Kelly and Dr. Niedermeyer for their assistance in facilitating this, for them hosting this, for the invitation to be a part of the grand rounds. So I know that they've been instrumental in those efforts, and so they are owed a big thanks for their contributions here. So I'm glad to turn it back over to Justice Stratton. If you wanted to close us out, Your Honor, Magistrate Morris, if you had any concluding comments, or Christina, we can do that now, and if not, we could wrap things up and turn it back over to Dr. Kelly.
So I'll conclude with a few comments, and feel free or the others if you want to, but we're hoping by this presentation to get you interested. This is a lot of pretty high level stuff that we threw at you, some very technical issues and some procedures that sometimes takes years of practice to really understand. But we wanted to give you just a feel for some of the legal issues in the civil system and their interface in the criminal justice system, so that when you get out into practice, whatever area you go, you will be aware of them, perhaps study up on them more thoroughly, or perhaps even go into a field where you can be directly involved with this type of work, because we have such a shortage in this area. There are not very many psychiatrists who go into the criminal justice field. And so we always are having a lack of the personnel and a lack of doctors to work with, as you just heard from Magistrate Morris. So if you have any interest in going further into this field and want to reach out to any of the speakers to say, hey, I really care about these issues. I may have a family member with these issues that has made me more interested, or whatever your motivation is, please do so. And please consider getting more involved in this area, because we desperately need your expertise, your training, your background. And we really want to continue to work to break the cycle of mental illness and criminal justice, and the jails and prisons being the de facto hospital. We want to get to them soon, before they need to be involved in our system. So that's my pitch to you who are listening to this, and to hope that you take to heart some of the things you've learned, study them further, and be committed to get more involved. So thank you.
All right, thank you everybody for attending. We will have the link to this webinar available shortly, so stay tuned for that. If you have emailed me, then I will make note of that and make sure it happens also. So stay tuned though for our next part, whenever that time comes. We'll send out the calendar invite. And if you have any other thoughts or ideas of topics that you'd like to hear, also let us know. So thank you, everyone.
Thank you.
Thank you.
Thanks so much.
Take care.